ओके, वेलकम दोस्तों। लेबर लॉ एडवाइजर चैनल के इस वेबिनार नंबर 24 में आप सभी का स्वागत है। तो ये वेबिनार की कड़ी आगे से आगे जुड़ती जा रही है और एक से एक शानदार स्पीकर्स हमारे साथ आते जा रहे हैं इस सीरीज में। और आज का टॉपिक आई बिलीव इज वन ऑफ द मोस्ट रिलेवेंट टॉपिक जो हम हमारे करियर के लिए, हमारे बिजनेस के लिए कवर कर सकते हैं। और आज का हमारा टॉपिक, जैसे आपने वेबिनार का टाइटल पढ़ ही लिया होगा, आज का हमारा टॉपिक है लेबर लॉ कंप्लायंसेस अ बिजनेस मस्ट डू। तो बिजनेस के कौन से स्टेज पर कौन सी लेबर लॉ कंप्लायंसेस उसके ऊपर लागू हो जाती है और बेसिक ब्रीफ उनके लिए क्या क्या हमें कंप्लायंसेस करनी पड़ती है। जैसे कुछ बेसिक्स तो आप सभी को पता होगी, जैसे ESI 10 के ऊपर लागू हो जाता है, PF 20 के ऊपर लागू हो जाता है, लेकिन उसके अलावा और बहुत सारे एक्ट्स हैं, बहुत सारे लॉज हैं। इवन दो हमारे 4 कोड्स आने वाले हैं, अभी लागू नहीं हुए, आने वाले, उससे थोड़ा सिंप्लीफिकेशन होने की संभावना है, लेकिन उसके बावजूद ये सिनेरियो बहुत कॉम्प्लेक्स रहता है और ज्यादातर HRs को, बिजनेस ओनर्स को आइडिया नहीं रहता कि उनके बिजनेस के किस स्टेज पर उनके ऊपर कौन सी कंप्लायंसेस आने वाली है। तो आज उसी को हम आसान बनाएंगे आपको इस वेबिनार में। हमारे स्पीकर को मैं इनवाइट करूं उससे पहले आप सभी से पूछना चाहता हूं कि अगर आपको आवाज वगैरह प्रॉपर आ रही है तो आप प्लीज मुझे चैट में बता दीजिए। अगेन, आपके जो क्वेश्चन रहेंगे हमेशा की तरह आप मेरे से चैट में पूछते रहिएगा और जब भी अवसर मिलेगा तो हम उन क्वेश्चंस को लेंगे। और वेबिनार के एंड में तो हम सारे ही क्वेश्चन लेने की आपकी कोशिश करते ही हैं हमेशा, तो क्वेश्चन लेंगे। तो एक बार मुझे चैट में, अगर आपको आवाज प्रॉपर आ रही है, आप आराम से स्क्रीन देख पा रहे हो, तो मुझे चैट में बता दीजिए। थैंक यू सो मच। हाँ जी, चलिए, थैंक यू सो मच। आई गेस आवाज इज ओके और एवरीथिंग इज ओके। आप सभी को गुड आफ्टरनून। तो आज के जो हमारे स्पीकर हैं, मैं उनके बारे में जितनी बातें बताऊं वो कम होगी, क्योंकि मैंने पर्सनली उनके डजन्स ऑफ वेबिनार, जिनमें आइदर वो स्पीकर रहे हैं या फिर ज्यादातर में वो एंकर रहे हैं, अटेंड किया है। उनकी बात करने की शैली का, उनके समझाने की शैली का मैं खुद बहुत बड़ा फैन हूँ और उनका कभी भी कोई वेबिनार होता है तो मैं मिस नहीं करता हूँ। इनफैक्ट पिछले 1-1.5 सालों में एप्पल का एक प्लेटफॉर्म है जिसके थ्रू मैंने बहुत सारे वेबिनार अटेंड किए, बहुत कुछ सीखा और बहुत उसमें मजा आया है। तो आज के हमारे स्पीकर हैं, उनका नाम है दयानंद मनगांवकर। शायद आप में से कुछ लोग उन्हें ऑलरेडी जानते होंगे। वो पिछले 28 ईयर्स से, जी हाँ 28 ईयर्स से लेबर लॉ कंप्लायंसेस, एम्प्लॉयमेंट लॉस की कंप्लायंसेस देखते हैं, इसके एक्सपर्ट हैं। ना सिर्फ इनकी कंप्लायंसेस करते हैं बल्कि इसमें ट्रेनिंग और बहुत सारे उनके रिप्रेजेंटेशन इस श्रेणी में उनके चलते हैं। और इसके अलावा वो जो पॉश एक्ट है उसके भी बहुत एक्सपर्ट हैं और कई सारे ICs के वो मेंबर भी हैं। तो मैं आज मंच पर बुला रहा हूँ दयानंद सर को। सर, वेलकम टू LLA वेबिनार। सर, थैंक यू फॉर गिविंग योर टाइम एंड वेलकम टू LLA वेबिनार।
Most welcome. Thank you. Let me adjust my screen.
जी,
Shall I start?
Yes sir, बिल्कुल, you can start.
Can everybody see my screen?
Yes sir, perfect.
Yeah, thank you. Good evening everybody, and on behalf of LLA, I welcome everybody on this webinar on applicability of labor laws to various businesses and basic compliance they are under, which is organized by LLA Labor Law Advisor, which is in the 24th series webinar. I'm really proud of Mr. Rishabh Jain said that this is a continuous series of the 24th webinar on the subject matter, and I was really surprised when he told me about the just beginning of the program. I was speaking with him. I understood that it came to my notice that he is even though he is handling this particular platform for the labor laws, his basic qualification is a BTech engineer, basically in the civil engineering. Excellent. It's a wonderful combination, basically, because if you see in the labor, this LLB institutes or the colleges, you will find most of the advocates, their basic qualification is a science, they are science graduate, either BSc or MSc, because you know that for law graduation or to become advocate, you require an analytical mind, and this analytical mind is normally usually possessed by the science graduates. However, Rishabh Jain ji has completed BTech engineering. I think so he must be having a super analytical mind, and once he completes his law graduation, this is the most successful. I can say that next to our Harish Sir, he will be there. I can see it on the television. Friends, I'm once again welcoming you. This is webinar on this subject matter. The topic given to me is the labor laws to various business, applicability of the labor laws to various businesses, and the basic compliance. What is the basic compliance? It's an excellent program, basically, especially for the startups or those who have completed their 3 to 4 years experience as a HR. Because as you know, presently the HR managers, when they complete their degree, graduation, or qualification, normally these people, they have a lot of knowledge about the human resources. Human resources is a new concept which has come recently in last 15 to 20 years. Earlier it was either a personal manager or industrial relation, because a lot of problems were there. Manufacturing activities used to face a lot of problems from the workers union, trade union. However, this concept gradually has changed to human resources, exploiting and utilizing maximum human resources by granting them voluntarily the welfare schemes, basically. And therefore these HR managers, they might be master in their HR field, but some or other way they try to hesitate to get into this labor law compliance, because they think that this is not my job, this is the job of the timekeeper. No, friends, as a HR manager, you need to have all these angles of all these dimensions and the angles of this labor law compliance in the HR, and labor law is an integral part of the HR. Now let us understand what is this labor laws. Basically, labor laws are nothing but the set of regulations, rules, sections, definitions, and more predominantly the set of compliance also. Compliance is an integral part of all labor laws. Now, labor laws also puts responsibility on workers, employees, and employers, to whom usually we call them as stakeholders. And main objective of this labor law is to regulate rights of the workers and laborers. However, these labor laws, all these labor laws are divided into 4 parts. Now, these labor laws are basically divided into 4 parts. As you know that we have around more than 169 labor laws, central as well as the state laws, because as you know that these labor laws falls under concurrent list. Now, what is this concurrent list? In detail, we will discuss, so that you will be very clear about this particular subject and why these labor laws are included in the concurrent list of the Constitution of India, which is the basic knowledge you need to have. But as I was telling you that these labor laws are the state and central enacted 169 labor laws are the main primary object of this labor law is divided into 4 parts. Now, what is the first part? The first part mainly talks about regularizing the working conditions of the workers and employees working in the factories, establishment, mines, and those who are employed through the contract laborers. So this basically first part is handled by the Shops and Establishment Act, which is necessarily the state enactment. Then manufacturing, factories, that means the workers engage in the factories, so they're regularizing their working conditions, a part of Factories Act. And mines, for the purpose of mines, regularizing the working condition of mines, there is a Mines Act and the Contract Labor Act also. So this is basically the first part of this labor law. Now the second part necessarily talks about the extending medical, insurance, and retirement benefits, and the profit sharing and the welfare things to the employees, basically to the workers. Now these medical and insurance facilities, as you know that it is done through the ESI Act. Retirement benefits like the pension and provident fund is handled by the Provident Fund Act. Profit sharing, of course, the Payment of Bonus Act, and the loyalty is normally given to the employees through Payment of Gratuity Act. The third and most important objective of this labor law is to provide wage payment related issues. What is the due date of the wage payment? Now, what are the permissible deduction from the wages? This is handled by the Payment of Wages Act, and how much minimum wages to be paid, and to which industry the minimum wages are to be paid. These are the basically things which are handled by the Payment of Wages Act 1936 and the Minimum Wages Act 1948. Now, first and the last and the fourth part is to provide the dispute redressal mechanism. As you all know that these labor laws are primarily related to the employment base. Most of the labor laws are employment based, and very few are establishment based or the factory based. Now, labor law itself suggests that the name of this labor law is a laborers, so it is meant for the laborers, which this particular point aspect has been eliminated in the codification. Today's session we are not going to discuss much about codification, because for that purpose we will require a separate webinar of more than 1 hour. But I will have a cursory glance on this particular codification while discussing with all of you. As I told you, friends, that the labor laws falls under the concurrent list, unlike revenue laws. Income tax is a revenue law. However, income tax does not fall under the concurrent list. Why and how, I'll tell you. The Income Tax Act basically is the entire sphere and the periphery of the central government, and no state government can interfere in the Income Tax Act. However, as per the Constitution of India, the labor laws, as we have a federal structure, state as well as the central, we have a federal structure in the Constitution, and the labor law has been given the place in the concurrent list. This means that basically central government as well as state government both are empowered to enact the labor laws, whatever they want, or based on their need of their workers residing in their state and the region. Based on that, they can formulate the labor laws. No doubt, whenever the state government formulates or enacts any labor laws, they have to get it first approved, assented from the governor of that particular state, and later on they have to get it approved from the President of India. Same way, in the advantage of having the concurrent list is that when the central government passes any law, state government has got powers to carry out the amendment in the Central Act also, like Factories Act, Contract Labor Act, Gratuity Act. Most of the state government, even though the Central Gratuity Act says that it becomes applicable to you once you have 10 and more than 10 employees, same way the Factories Act also, Central Act says that the act will be applicable to you once you have 10 and more than 10 employees with power, and 20 and more than 20 employees if the manufacturing activity is carried out without power. Same way about the contract labor, the Central Act says once you have 20 and more than 20 employees, the act becomes applicable. However, in the recent, as a part of carrying out or doing the ease of doing business, most of the states have enacted this Factories Act, Contract Labor Act as well as the Gratuity Act based on their requirement and necessity. Factories Act, as most of the states, they have said that it will be applicable for 20 with power and 40 without power. Earlier it was 10 with power and 20 without power. Now it has in most of, like including states of Maharashtra, Gujarat, they have said that the Factory Act in their states will be applicable for the factories having 20 and more than 20 employees carrying out the manufacturing activity with power. And Contract Labor Act also, most of the states, earlier it was 20 employees, which has been enacted and enhanced to 50 employees. So this is the beauty of this, putting these labor laws into concurrent list, in the concurrent list. Now let us understand labor laws compliance or not. Now, what are these labor laws? Basically, what is the labor law compliance? Now, labor laws compliance are not just filing of returns or updating the register and records. It carries much more importance. And what are these things that we will understand? Now, along with the filing of returns and registers, the main important factor of this compliance is that extending, you have to ensure that as a HR person, it is indirectly the social worker or the social welfare officer of that company, and he has to ensure that the benefits are extended to the workers, laborers who are working for the factory, who are putting their efforts for the company, growth of the company, who are integral part of the entire business processes. The benefits are going to these workers or no, that you have to ensure. So compliance, the extending benefits to the worker is also part of compliance. So also deciding the eligibility of criteria, whether that one particular employee or the worker is covered under ES Act, whether is covered under Gratuity Act, Bonus Act, Provident Fund Act, that also needs to be ensured, which is again integral part of the compliance. So also maintaining these records, as a part of maintaining these records, is serves the evidence for the auditors. Whenever the audit takes place in your company, or the assessment takes place, inspection takes place from the government authorities like ESI inspector, now they are called as a social security officer, or Provident Fund enforcement officer. Whenever they come for the inspection, definitely they ask for these returns, records, register, which are maintained under part of the compliance under various labor laws. So this is as far as the compliance or the various dimensions of this compliance. Now let us understand which are the labor laws presently enacted in India by central government. And today we are not going to discuss anything about this codification, because as I told you initially, the codification itself is a vast subject basically. But as a cursory information, I'll give you that totally in the codification, the object of the codification is to generate the ease of doing business, carry out more and more simplification, because these labor laws were enacted from time to time and not on one particular year. Because you see, the Payment of Wages Act was enacted in the year 1936, pre-independence era. Employees Compensation Act, which was earlier known as the Workers' Compensation Act, was enacted somewhere in the year 1923. Trade Union Act was also quite old prior to independence. ES Act was of 48, PF Act was of 52, gratuity again 72, contract labor of 70. So from time to time, this enactment, as and when required, government thought it appropriate to enact the laws because they wanted to establish the industry in India, and therefore all these laws were not enacted on any single day. Now the time has come to consolidate all these labor laws, and therefore government thought it appropriate whatever central laws are there. So they identified around 29 central laws which they are codified into 4 different codes. Now, friends, I'll tell you that this particular codification, many people ask me what is the meaning of this codification. Codification is not enactment of the new law. As you know that GST is a codification. It was not new law, because GST, what happened, the consolidation of various state sales tax, central sales tax, luxury tax, and various other taxes got merged together, and one GST came, that is a goods and service tax. Same way, in the codification is nothing but a rewriting, is nothing but the new enactment of the new law. It is a rewriting of the law or consolidation of the law. So presently, out of these 29 labor laws, there are 4 codes are there. The first code is a code on wages 2019, then code on social security 2020, code on industrial relation 2020, and code on OSH, that is occupational safety, health and working condition 2020. So presently we will restrict our discussion as far as codification is concerned only up to this particular understanding, but later on I will give the opportunity to you for asking your questions pertaining to this. In the meantime, we will see presently how many central laws are there which are applicable to various types of industry. Because as a HR manager, you must be representing large number of various types of industry. Some may be from engineering, another may be from the establishment, hotel industry, some may be from the textile industry. So for different types of industries, the different laws are applicable. However, here the list I have given you is basically the list of common laws. The first and foremost law is the Apprentice Act 1961. Now, when this act becomes applicable, what is the basic criteria for applicability of the act? In the coming slide, we will see it. So, presently, I'll tell you the Apprentice Act 1961, which is mandatorily applicable to all establishments engaging 4 and more employees. Building and Other Construction Workers Acts, as you know that whenever any construction work is carried out, including the housing society, not only in the establishment but in the housing societies, the Building and Other Construction Workers, which is popularly known as BOC Act 1966, is applicable. However, if any construction work or the extension of the premises is taking place in the premises of factory, which is registered under Factories Act, then BOC Act is not applicable over there. However, for rest of the construction building, construction companies, construction of the houses, this BOC Act is very well applicable. Contract Labor Act basically talks about the Regulation and Abolition Act 1970. This is a unique act where the regularization of the contract labor is provided at the same time. In case of a violation of particular provisions of this act, there is a provision given to the advisory committee or the authority to abolish the act, which is of 1970. Child Labor Act. Earlier, this particular Child and Adolescent Labor Act was known as a Child Labor Act, which has been reenacted in the year 1996, and now it is known as the Child and Adolescent Labor Prohibition and Regulation Act. So, new word in child labor is introduced, that is the adolescent labor. Employees Compensation Act 23. Now, Employees Compensation Act, earlier known as Worksman Compensation Act, and in the year 2010, this Worksman Compensation Act was renamed as Employees Compensation Act 1923, wherein the definition of worker is enhanced and large number of employees. The worker definition is removed and the new definition employees introduced under the Employees Compensation Act, and many more categories of employees, because earlier this Workers' Compensation Act was necessarily applicable only to the workers. Now but because of this amendment in the year 2010, the government thought it appropriate to bring large number of even employees also working in various sectors, not only in manufacturing but in the establishment also, within the ambit of this particular Compensation Act of 23. ESI Act 1948, you all must be knowing that ESI Act, Employee State Insurance Act, which is a compulsory medical health and insurance scheme, which is applicable to all private sector and public sector establishments. Same way for the retirement benefit like a pension, provident fund, and insurance benefit, there is the Employees Provident Fund and Miscellaneous Provisions Act 1952 was enacted in the year 52. Many people do not know why this act has the word miscellaneous provisions. Basically, Employees Provident Fund and Miscellaneous Provisions Act. Here the miscellaneous provisions means what? Under this act, there are 3 different schemes are there, and private sector and public sector establishments employees are the only employees who are eligible for these 3 different schemes. Even government employees, banking sector employees are not eligible because they have got a general provident fund, which is not covered under this one. Now this employees provident fund miscellaneous provisions and miscellaneous talks about the first is the savings scheme, that is a provident fund. Secondly, it talks about the pension. On completion of certain years of membership, the employees will be eligible for monthly pension, superannuation pension, widower pension, orphan pension. Various types of provisions are there for pension. And third provision is the employees deposit linked insurance scheme 76. That is, while in employment, if any employee dies, then the employee's nominee will be eligible for lump sum insurance amount for which he doesn't pay, for which employee doesn't have to pay anything. It is his employer who pays certain contribution. Now, in this case, this what is the primary criteria? That employee should be on the roll of the company on the date of death. And now the minimum benefit under this EDLI is enhanced, minimum enhanced to 2,50,000 and maximum is enhanced to 7 lakh rupees. So now presently the PF office is giving more benefit than any private insurance company under this particular act. So as I told you, why this miscellaneous provision? So this miscellaneous provision consists of PF, which is a savings scheme, second is a pension scheme, and third is a EDLI, that is a employees deposit linked insurance scheme. The eighth and most important act is the Employment Action CNV Act 1959. Now, Employment Action CNV, what is the meaning of CNV? CNV is a compulsory notification of vacancies. This is government's own placement agency, which is statutory and mandatory, because as you know that unless and until anything is enacted or anything is regulated, no employer or no citizen of India follows the rules of this government. Just by declaring, okay, you do tomorrow onward, you do so and so thing, nobody will follow. Government has to come out with the particular enactment, and so that there will be penal provision also will be there in case of a non-compliance. The employment exchange is the government's placement agency sort of, and whenever any vacancies arises, this particular act says that you have to compulsorily notify your vacancies to the employment exchange, regional employment exchange, and from that you have to take certain employees, you have to call them for the interview. However, selection of these employees sent by the government or employment exchanges is not mandatory, but however, whenever you reject such candidate, you have to furnish the written in form ER1. In the compliance part, we will see it. You have to furnish information in form ER1 why you are rejected this one. The next one important is the Equal Remuneration Act 1976. Now, this Equal Remuneration Act 1976 was enacted by government, central government, to bridge the gap between gender gap between male and female employee, because there was initially or the earlier period there was a tendency amongst the employer that female employee having the same knowledge, same experience, same qualification as that of the male, they used to get the lesser salary even though they are working in the same category. And therefore this particular Equal Remuneration Act, which says that if any female employee working in the company having the same knowledge, same qualification, same experience, same as that of the male counterpart, she should be paid the same salary. This is very important act of 1976, but there is very less compliance is there. The compliance only one form number D you have to mention, that which gives the exhibition or the manifestation of equal remuneration paid or payable to the male and female gender in various classes and categories existing in the companies. Now, most important next act is the Factories Act 1948, which is applicable. Now, when this act becomes applicable, I'll tell you in my forthcoming slides basically, but Factory Act is very important because this act has got, we call it as the fattest act after the BOC Act, that is the Building and Other Construction Workers Act, because the Factory Act has almost got 101 section therein and large number of compliances are there. You all must know, if you are HR manager, you are representing any manufacturing unit, then you must thoroughly study this Factories Act 1948, because any non-compliance under this act, ultimately your employer or board of director can be prosecuted. Especially you must be knowing that what happened in the Bhopal tragedy, that is a Union Carbide, when the blast took place in the chemical that Union Carbide, what was the problem and how the directors were criminally prosecuted because of this particular negligence on part of the compliance. So Factories Act basically nothing but it talks about the safety matters, working conditions of the workers working in the factories and the manufacturing places. Next and important is the Cine Workers Welfare Fund Act 81, which is applicable to the film production and the cinema workers basically. Next, thereafter, Industrial Dispute Act 1947 is 47 is there. Now, as far as Industrial Dispute Act 1947 is concerned, there is no question of applicability because this particular act is nothing but the mechanism provided under this act for redressal of the disputes between worker and worker, disputes between worker and between employer and employer. In the codification, industrial disputes is playing a major role, which you need to understand subsequently. Thereafter, the Industrial Employment Standing Order Act 1946. This Industrial Employment Standing Order Act 1946 is nothing but the service rule. Many companies has got their own service rule in-house, and Industrial Employment Standing Order Act 1946 gives the statutory or regulatory provision as far as these industrial employment standing orders are concerned or the service rules are concerned. We'll discuss the applicability of this particular act also. Thereafter, important act which is applicable to all establishments and factories, Interstate Migrant Workman, that is Regulation of Employment and Conditions of Service Act 1970. You all must have experienced that during this lockdown period, when the trains were, the services of the trains, road transport were suspended. What was the plight? What are the problems these people face, migrant workers face? Since many on the television, you must have seen that they were going home on the road, on the walk, somewhere walking on with the family, they are walking on the tracks, and many people died also in the state of Maharashtra because of the accident. So for regularizing the working conditions of the interstate migrant workmen, as the government enacted this particular act in 1979. Thereafter, 1948, government enacted Minimum Wages Act 48. This is again important act and applicable to all establishment, all scheduled establishment basically. However, in codification, this schedule word has been removed, and Minimum Wages Act presently is applicable only to the said scheduled establishment or the scheduled industries. Scheduled industry means government in this particular act, government has given the schedule that these are the establishments or these are the manufacturing activities or the service industries to whom Minimum Wages Act is applicable. So you'll find that in this schedule, banking industry is not there, insurance company is not there, shipping industry is not there, aviation is not there. So to this presently to such type of industries, the Minimum Wages Act is not applicable. They have their own scale. For regularizing the rights of the benefits to the female employee when they go for a pregnancy leave or when they want a pregnancy leave for delivering a child, the Maternity Benefit Act is there, 1961, which was enacted very recently. Wherein the benefit was extended from 12 weeks to almost 26 weeks. So presently, as you know, that female employees undergoing this maternity leave are eligible for 26 weeks leave and many other benefits. Motor Transport Workers Act 61. Now, Motor Transport Workers Act 61 is applicable only for the industries where the motor transport workers are engaged, and it is very restricted act. Basically, it is not applicable to all establishment or the factories, but where basically the logistic and the transport companies or the companies who are availing the services of these transport workers, the Motor Transport Act 1961 is applicable. Next is about the profit sharing. Whenever any employer earns large profit, or even though after 5 years it doesn't earn any profit, it is a mandatory responsibility of the employer to give bonus to its employees. Now, when this act becomes applicable, what is the percentage of this bonus, we will discuss in the subsequent slides. Next and very important is the Payment of Gratuity Act 72. So even Payment of Gratuity Act 72 is also applicable, for which 5 years minimum condition is there for the employee. This is nothing but the loyalty, basically those who complete, those who serve for minimum 5 years, that government wants their employer to give some amount, that prescribed rate to its employees. However, this 5 years condition is applicable only for the live employee as on date of resignation. In case if any employee dies during the course of his employment before completion of 5 years, in such cases, even though he has not completed, that employee, the deceased person had not completed 5 years, his nominee will get gratuity based on number of years of service completed by him, which is even less than 5 years. Payment of Wages Act 1936, which was again enacted by the Britishers prior to independence, prior to pre-independence era, and this basically talks about or regulates due date for payment of wages and what are the statutory deductions and what are the illegal deductions. That means the deductions which are not permissible to be made from the wages. So mainly this Payment of Wages Act talks about these two things, that due date of payment and statutory deductions. Sales promotion employees, that Conditions of Service Act 1976 are mainly applicable to FMCG and the pharma companies. This is basically nothing but the medical representatives in case of pharma companies, and in case of FMCG, the sales representatives, the sales promotion employees Condition of Service Act 1976 is applicable. Next, an important act, very recently it was enacted, that is the Sexual Harassment of Women at Workplace, PPR Act 2013, that is Prevention, Prohibition and Redressal Act 2013, which was subsequently came to Nirbhaya case, and originally the entire act, the content of this act is based on Vishaka judgment, which was delivered by Supreme Court in the case of state of Rajasthan. And last and very important act is the Trade Union Act, which regulates which monitors the registration of the trade union. So these are the basically list of all central laws which are applicable. Now many employees, many HR managers ask, especially those who are from the IT industry, they have a little skeptical mind that whether any particular labor law is applicable to them. Please understand, except for the NGO as on today, once the codification takes place, all these labor law, all these codes will be applicable even to the NGOs also, that is a non-government organizations, trust, or the Trust Registration and the Societies Act. Presently, all these central labor laws are applicable to all private sector and public sector establishments and the factories, and no exemption is granted. Exemption is given only for certain compliances, but not from the applicability of that, because as you know that many employees who are representing the IT industry, information technology, or ITS, that is the information technology enabled services industry, they say, these are the labor laws. We don't have any laborers in our company. So please understand that even though the name of this labor law is a labor law, it is applicable, it is meant for employees, and it is applicable to all employees, all establishment, all categories of establishment of public sector and private sector establishment. Now I'll give the list of certain labor laws which are enacted by the state. The state has enacted at the outset. One is the Shops and Establishment Act. This is enacted by the state, and therefore I have not included it in the central list. Second is the Labor Welfare Fund Act. However, Labor Welfare Fund Act is not enacted in all states presently, but most of the progressive states like Rajasthan, Gujarat, Maharashtra, Andhra Pradesh, Haryana, all these states, they have enacted their own Labor Welfare Fund Act basically. And Profession Tax Act. Profession Tax Act is also a state act, but please remember, please understand, Profession Tax Act is not a labor law, it is a revenue law. However, since the deduction is to be made from the salary of the employee, most of the company's finance department or accounts department, they put the onus or responsibility on HR manager. Okay, you take care of this particular compliance under Profession Tax Act, and therefore HR manager must know what is this Profession Tax Act, when it is applicable, what is the deduction to be made, when it is to be filed, and because now most of the things are gone online. So these are the basically three acts which are the state acts, out of which Profession Tax is a revenue law and not the labor laws. Friends, we have seen how many labor laws are there in India which are applicable to various types of industries. Now let us see the applicability part of it, which is very important, especially for the startup, so that you can assess and analyze whether that particular act is applicable to you or no, and the doubt in your mind, if it is lingering about the applicability, because many HR managers are hesitant to ask this question even to the government officer or the officers of respective government department, ESR department, PF department, because moment they ask, they have a fear in the mind that tomorrow the team of inspector will come and sit at their establishment or the factory, and the entire problem will be arise. So you need to understand this basic aspect, that when this act becomes applicable. ESI Act, friends, is applicable with 10 or more than 10 employees engaged in manufacturing activity. If your company is engaging manufacturing activity and that manufacturing activity is being carried out with the aid of mechanical power, that is the electrical power, in such cases, and if you are having 10 or more than 10 employees, then the ESI Act becomes applicable. Earlier, for service sector establishment, the ESI Act used to become applicable when you have 20 and more than 20 employees. But very recently, in the year October 2020, the government has come out with the notification. And in most of the states, the ESI has been made applicable even to the service sector establishment with 10 and more than 10 employees, and 20 employees criteria has been removed. Now, when the PF Act becomes applicable, we saw when the ESI Act becomes applicable. Now, let us see when PF Act becomes applicable. PF does not, just like ESI differentiate, as far as applicability is concerned, ESI Act differentiate between factory, that is the manufacturing establishment, and the service sector establishment. PF does not differentiate between factory and establishment. PF says moment you have 20 and more than 20 employees, the act becomes applicable whether you are a factory or establishment. However, under Provident Fund Act, PF being a saving scheme, under Provident Fund Act, there is a provision for voluntary coverage, and if you have got less than 20 employees also, any establishment or the factory on voluntary basis can go for a registration and extend the benefits of PF, saving scheme, pension, retirement benefit, and insurance scheme, that is the EDLI, all these three benefits for its employee. Now let us see when the Gratuity Act becomes applicable. Gratuity Act at the first instance become applicable to the establishment or the factory once it has got 10 and more than 10 employees. Here again, it doesn't differentiate between factory and establishment. Both, whether it is a factory or establishment, the Gratuity Act becomes applicable once it has got 10 and more than 10 employees. However, the employee becomes applicable for the payment of gratuity on completion of 5 years of his continuous service, and in case of a death, if the employee dies before completion of the 5 years, as I told you earlier, the Gratuity Act will be applicable to the nominees or the legal heirs of such deceased person. Now let's see when the Bonus Act becomes applicable. Now here again, Bonus Act, just like ESI, Bonus Act differentiate between factory and establishment. Bonus Act for the factories, it becomes applicable when it has got 10 and more than 10 employees, while for establishment it becomes applicable when you have got 20 and more than 20 employees. Factories Act. Now, when this Factory Act applicable, very interesting thing, because again, large number of states have come out with a different thing. So initially, what was the provision for applicability of the Factories Act? We will see. Factory Act, just like ESI Act, the Factory Act becomes applicable when you have got 10 and more than 10 employees and carrying out the manufacturing process with the aid of power which is mechanically generated, that is electricity. So Factory Act, initially it was applicable for as per central provision with 10 and more than 10 employees, and where the manufacturing process is carried out and electrical power is not utilized. In such cases, the Factory Act becomes applicable once you have 20 and more than 20 employees. However, most of the states from this 10 and 20, with the aid, with the intention, with the motto of creating more and more ease of doing business, most of the states, they said that the Factory Act going forward, it will be in the state of Maharashtra. I don't know about Rajasthan whether this has been notified or no, but I presume that it is notified now, because most of the states have amended its applicability provision, and they said that instead of 10, now this enhancement has become, this applicability has enhanced to 20 employees. So once you have 20 and more than 20 employees and carrying out manufacturing process with the aid of electrical power, the Factory Act will be applicable. And if the electrical power is not utilized for the manufacturing process, then this Factory Act will be applicable once you have 40 and above 40 employees. So earlier it was 10 with power and 20 without power, which has been amended to 20 with power and 40 without power. Now here you need to understand what is the definition of this manufacturing, because there is a lot of confusion amongst these HR managers or the owners of the company about the applicability of this factory or whether you fall under the manufacturing process or no. Please understand, manufacturing, the word manufacturing, you should not take in the literal sense. Petrol pump, if you go to the petrol pump, there the tanks are kept under the ground, and petrol, when they fill the petrol in your vehicle, when you go to any petrol pump, the pump is put in the fuel tank of the vehicle, and that petrol comes from the ground, underground tanks, and this underground tank pumping is done with the electrical power. So even such type of pumping is nothing but the manufacturing process. Ironing of the clothes, stitching of the clothes is manufacturing process. So you please understand, except for data processing and manufacturing of the food, except for data processing and the manufacturing of the food in hotels and restaurant, it is not a manufacturing process. In hotels and restaurant, even the mixer is used for production of the food. It is not considered as a manufacturing process. However, same way in IT industries or IT industries, if any company is doing data processing work, then that particular activity is not considered as factory or manufacturing process. Now let's see that when this Apprentice Act becomes applicable. In Apprentice Act, there are 3 divisions are made. Apprentice Act becomes applicable once you have 4 and more than 4 employees. However, engaging apprentice, having the establishment or the factories 4 and more than 4 employees, but below 30 employees, it is optional. Engagement of apprentice is optional. However, if you have got 30 and more than 30 employees, then engagement of apprentice They are given certain percentage are there for applicability of this Apprenticeship Act. For the establishment or the factory having 30 and more than 30 employees, you have to mandatorily engage apprentices. There are a large number of benefits are there, because as you know that the government has come out with the NEEM scheme, then NAPS, that is a National Apprenticeship Promotion Scheme, and there are a large number of benefits are there. I think so. My friend Rishabh has had attended my program on this particular topic. Is very well. Subsequently, we can, or maybe in the next one, we can hold a similar type of session on the Apprentice Act and understand what are the benefits and how you can control your wage bill by engaging apprentices in your company. And this is also beneficial because there is central government has started incentivizing the employer for engaging apprentice. So if you engage any particular apprentice, then in that case 1500 rupees is given back to the employee per apprentice as a form of stipend. So also if you have got a basic training center, then 7500 is cash benefit is given to the employer. Now let's understand when the Sexual Harassment of Women Act is applicable. Now Sexual Harassment of Women Act becomes applicable if you have got 10 and more than 10 employees. The establishment of the factories having less than 10 employees, they need not to have, the act is applicable to them, but they need not to have their own committee, internal committee. They can do it with the local committee or the local committee of the district. Here, please understand, many companies, they say that they have got all gents employees. They say we do not have any women employees. So why this act is applicable? See, here, please understand, Sexual Harassment of Women Act talks about the applicability, which says that if you have got 10 and more than 10 employees, it doesn't say that 10 and more than 10 female employees. It clearly says that if you have got 10 and more than 10 employees, so whether female employee, male employee, or total all female employees, still this act becomes applicable. So don't get confused between this applicability, that since you do not have any woman employee, the act is not applicable to you. It is very well applicable. You have got, even though you have got 100% male employees. Only thing is that if you have got 10 and more than 10 employees on your roll, then you need to have an internal committee in-house basis. And if you have less than 10 employees, the provisions of the act will be applicable. However, you don't have to formulate your own internal committee. You can go with the local committee of the district, which is maintained by the district officer or the Tahsildar office. Now let's say about the Shops and Establishment Act. Shops and Establishment Act, its applicability varies from state to state because it is a state act, and in most of the states, if wherever the things are got online, now they says that in the state of Maharashtra, if you have got 10 and more than 10 employees, then you have to take a license. And if you have got less than 10 employees, the provisions of Shops and Establishment Act are applicable. However, you don't have to take a license, but you can do away with the license by obtaining certificate of intimation. You have to just online basis, you have to intimate to your local authority. In Maharashtra, it is the municipal corporation wherein these licenses are given. So Shops and Establishment Act being a regional act or being a state act, you need to find out its applicability in each state. As far as LWF Act is concerned, same way again, LWF Act, Labour Welfare Fund Act is a state act, and it becomes applicable in most of the state. It becomes applicable once you have 5 or more than 5 employees. CLR Act is a central act. However, most of the states have carried out the amendment in their applicability, and in most of the states, now it becomes applicable with 50 and more than 50 employees. Earlier, the applicability of the CLR Act was with 20 and more than 20 employees. Now, what is the compliance under this act? We will discuss, because under Contract Labor Act, there are 2 types of compliances are there. One compliance which is to be done by the principal employer, and another compliance which is to be done by the contractor having 20 and more than 20 employees. So, principal employer has to take a registration certificate. If he has got 50, if he is engaging services of the contractual employees through contractor, through one or more than one contractor, and engaging 50 and more than 50 workmen through such contractors, then principal employer has to take a registration certificate, while the contractor has to take a license if he is rendering the services or providing the laborer to principal employer at one particular premises with 50 and more than 50 employees. Now, when the state Interested Migrant Workmen Act becomes applicable, we'll see it now. Interested Migrant Worker, that is the ISMWR Act, becomes applicable once you have got 5 or more than 5 employees. Again, the compliance under this act is very stringent, because these workers, as you know, that these workers come from the different state. They do not have a residence. They do not have accommodation to stay. Food is a problem. The children, education of the children is a problem. Getting medical and the health benefits is a problem, and therefore there are a lot of stringent provisions are incorporated in this particular act. And especially after this lockdown, the government has asked all state government to submit the data, how many interested migrant workmen are working in each state, and based on that, government is going to come out with a new policy for this ISMW, that is Interstate Migrant Workmen. Next act, as I told you, that the Motor Transport Workers Act, which becomes applicable once you have 5 or more than 5 employees, more than 5 motor transport workers, right? So if you have got 5 and more than, basically this act is applicable to the logistic company who have a fleet of 4-wheeler transports or the 2-wheeler transport. Next is applicability about the Industrial Employment Standing Order Act, and this act becomes applicable. This is again the central act, and this act becomes applicable to most of the industrial establishment engaging 100 and more than 100 employees. However, again, as I told you, that all this labor law falls under the category of concurrent list. The many state governments have made this particular act applicable with 50 and more than 50 employees, and Maharashtra is one of the progressive state where this act becomes applicable to the industrial establishment where 50 and more than 50 employees are there. Now, last and foremost important act we will see, that is the Maternity Benefit Act, when it becomes applicable. Now, this act becomes applicable with 10 or more persons employed for wages. Again, here, even though you do not have any female employees working at your establishment, beneficiaries will not be there, but the provisions of act will be applicable to your establishment or the factory once you have 10 and more than 10 persons employed for wages. So you need to understand the return. There is a provision for filing the return under Maternity Benefit Act. Annual return you have to file, which if you have got all male employees, then you have to file the nil return in form number 11. So also you have to maintain register in form number 10. Now, friends, we saw this. What are these labor laws? Are there central labor laws? We also saw what are the state labor laws. Their applicability criteria, which is based on number of employees, minimum number of employees. We saw the applicability. As I told you, that applicability with the head counts is basically for applicability of the act with applicability of act to the establishment or the factory. But once this act becomes applicable to the factory or establishment, then the act becomes applicable to its workers or employees. Same with the ESI. Now, this applicability of the act, like ESI, PF, bonus, this applicability is decided based on the wage criteria. Now, what are those wage criteria? In the subsequent slide we will see. Now, in the meantime, I'll tell you that under ESI, what are the primary, fundamental, and very important compliances you need to do. Once the ESI Act becomes applicable, you have to do registration. Now, if your company is a LLP, that is a limited liability partnership firm, or private limited company or public limited company, then you have to carry out this registration of the establishment or the factory on MCA portal from where the company is incorporated. So it is mandatory. If it is a private limited or LTD or LLP company, then you have to form this registration. You have to complete formalities from MCA portal. If it is a proprietary concern or purely partnership firm, then you can do it on the ESI portal. Then once the registration is done of the factory or the establishment, then registration of the employees, it is the responsibility of the employer to complete the registration of the employees within 10 days from the date of joining. And any non-compliance on this particular part, please note that there is a violation of this regulation and employer can be prosecuted along with the penalty or only with the penalty either of one. Same way, third and very important, which is the primary compliance basically under ESI, is the payment of contribution. At what rate it is to be contributed, we will see it in the subsequent slide. The payment of contribution which is to be made on or before 15th of each month is very important compliance, because as you know that non-compliance, non-payment, paying this contribution with the ESI authorities on or before 15th of each month shall attract penal provisions and not excluding prosecution. That uploading of annual return or the return of ownership, that is form O1A, is mandatory requirement under ESI Act. So ESI Act, what is the compliance? Basically registration of the company, then registration of the employee, payment of contribution, and uploading of form O1A. These are the mandatory things basically. Same way under Provident Fund Act.
Sir, I request you have a couple 1 minute break and have some water. I mean, you are speaking since 40 minutes.
No, I'm having my water in between also. Yeah, because my glass is.
Thank you.
Anyway, thank you. Yeah, I'll continue with this. EPF Act. Now, compliance under EPF Act, you need to understand the registration again on MCA portal whenever it is the LLP or the private limited company, then generation of UN number, and seeding of the same with KYC is mandatory. Now friends, very recently from 1st June 2021, the Provident Fund Office has come out with a circular that employees, those who have joined prior to 2017 or 2014, for them also the verification of their UN number with Aadhaar and seeding with Aadhaar is made mandatory, without which the challan will not be generated and employee will not get the benefit, and therefore just generating the UN number will not suffice the purpose. UN number, seeding this UN number with the KYC like Aadhaar number, PAN number, bank details, mobile number is made mandatory from 1st June 2021 for everybody. Basically, for new employee it was already there. Now for those old employees for whom it was not applicable or optional, now it has been made applicable for such employees also. Again, just like ESI, payment of contribution under PF is also mandatory, which is on or before 15th you have to pay, and uploading of annual return, that is a return of ownership, in Form 5A is mandatory. As you all know that under ESI and Provident Fund, the compliance has gone online. So creating the DSC, that is a digital DSC, that is a digital signature, digital certificate of signature, and taking the dongle for the purpose is again essential thing. Without that, you will not be able to carry out any online compliances. If any employee is making application for transfer or making application for withdrawal, the approval needs to be done by the employer, for which DSC is required. So along with this compliance, the DSC should also be in the basket of compliances or the checklist of compliances to ensure that whether the employer or the HR manager or the authorized signatory prescribed for the EPF has DSC signature is taken or no. Now Bonus Act, as I told you that compliance under the Bonus Act, that annual return in Form D and payment of bonus. Now Bonus Act necessarily becomes applicable on completion of 5 years of service, of 5 years of the company. From the date of incorporation, if any company has completed 5 years, the payment of Bonus Act becomes applicable once it has got 10 and more than 10 employees for factory and 20 and more than 20 employees for the establishment. Now for the purpose of this, whether this company has completed 5 years or not, this particular payment of bonus becomes payable on completion of 5 years mandatorily. During these 5 years, from first year to 5th year, if any company incurs a profit during this first 5 years, then again that exemption is withdrawn, and third year, let's say third year the company shows profit in its books, then payment for that particular year, third year, is mandatorily to be given to the employees. Again, on 4th year, if the company doesn't incur any profit, then 4th year need not to be paid. However, on completion of 5 years, whether company incurs profit or losses, payment of bonus will be mandatory, and minimum 8.33 and maximum 20% of basic plus DA is mandatory for the employees whose basic and DA or the bonusable salary is up to and inclusive of 21,000 per month. As you know that in 2014, the government has come out with the enactment or changes in the calculation process. Earlier, for the purpose of this bonus calculation, 3,500 was taken as the base salary. However, from 2014 onwards, the government said that for minimum salary for calculation of bonus will be either minimum wages applicable to your scheduled employment or scheduled industry, and if your company does not fall under the scheduled employment or scheduled industry, then 7,000 rupees as the minimum base you have to take for the computation of bonus, and that is what. And whatever bonus you pay, you have to maintain Form A, Form B, Form C and Form D. Form D is annual return. Form A is a register of set on set off. Form B is a register of available surplus, allocable surplus, and Form C is a register of bonus in which you have to make the payment of bonus. Now, what is the compliance under gratuity? We need to understand that. Under the Gratuity Act, when the Act becomes, as you know, that Gratuity Act becomes applicable to its employees on completion of 5 years of continuous service. However, for establishment of the factory or the company, it becomes applicable from the day one, and therefore, moment any company, any business is started, you have to file application in Form A, that is the intimation of commencement of business. Then after 1 year of completion of any employee's tenure, the nomination form in Form A4 to be obtained, and payment of gratuity, the employer needs to ensure that once any eligible employee leaves the company, that is on completion of 5 years, the gratuity must be paid, must be settled within 30 days from the date of exit, and any violation on this particular part, the employer can come in trouble, company can come in trouble, and it will tarnish the image of the company, not excluding prosecution of the director or the employer or the partner or the proprietor as the case may be. And also you'll have to pay the interest, penal interest on this delayed payment at the rate prescribed by State Bank of India. Factory Act. There are large number of compliances are there under Factories Act. If you are engaging, representing any factory manufacturing unit, you should be very careful about this, because Factory Act is such an act where the engineering knowledge is required. You need to have the welfare knowledge also. As a HR person, you need to have a safety provisions. What are the safety provisions? The basic knowledge about these three factors you need to understand and have it. And once you go through the Factory Act, you will come to know that how complicated the Factory Act is there basically. The first and foremost is the stability certificate. After for the new establishment, stability certificate is given by the architect. However, once the factory establishment completes 5 years, then after 5 years they have to obtain stability certificate from the competent authority. Then inspection report of PV, that is a pressure vessel, air compressor. Now inspection report of the pressure vessel or compressor is mandatory. Is mandatory after 6 months you have to take it. As if you are having an air compressor or a pressure vessel, for external check you have to carry out the inspection report. You have to carry out the inspection of the pressure vessel or the device after 6 months, externally, and internally once in 12 months. Air compressor is also same. Pressure vessel, air compressor, one are the same device. Health checkup of the employees is mandatory. Then use of PPE kit, that is a personal protection equipment kits, that is wearing of the hand gloves, shoes, safety shoes, eyewears. So these are the PPE kits you have to ensure that in the manufacturing process you have to give them use of mask. These are the integral part of this PPT, and it should be there. These items should be there in the employer's storeroom, and no charges to be claimed for supplying these PPE kits to the worker. The employer is not supposed to take any deposit or any charges for the use of these PPE kits. If any worker is working on the height, more than 12 feet height, then the work permit for working on height is required. You have to ensure the proper training should be given to those who are going to work on the height, and the work permit needs to be taken from work permit should be issued to such the workers who are working on the heights. Ambulance, the engagement of the ambulance is applicable once you have got 500 and more than 500 employees in your company. You need to have ambulance facility, ambulance room is required. And same way, the medical officer is also required in case of hazardous establishment. That means chemical processes. Once you have got 250 and more than 250 workers, keeping the doctor on duty, doctor is important. First aid is very important and integral part, and it should be placed at the first aid box should be placed at the distinguished places with the Red Cross mark thereon. And you have to periodically ensure whether any expiry dates or any medicines are expired or not. If any medicines are expired, you have to ensure that immediately they are replaced. Along with the first aid box, you have to put the list of the medicines which are there, which are kept in this box. And in the Factories Act, they also mention what are the ingredients, what are the basic medicines you need to keep in this first aid box. You can't just keep the bandage, Band-Aid or Bernol or Dettol. You have to keep, there is a lot of around 52 items they are given, and all those items you need to ensure that these are kept in the first aid bag. Same way, the fire equipments are also required. Water test report is required, especially drinking water. Then the test report for pulleys and hoists, cranes, if you are having cranes, then the test report is required to be taken on the periodical basis. Eyewash facility, especially those who are into the chemical or the hazardous process, the eyewash facility should be provided at specific distance. Drinking water, then cold drinking water facility should be provided. Latrines, how many number of latrines are to be there, that ratio is also provided for each 50 workers. For 50 workers, one latrine should be provided. Restroom facility is required. Medical inspection room is required. Welfare officer, once you have got more than 1000 or more than 500 employees, the engagement of welfare officer is mandatory. Same way for safety officer, if you have got 1000 and more than 1000 employees, appointment of safety officer is mandatory. However, state government has been asked that if any factory in its state is engaging in hazardous process, then this 1000 employees criteria can be reduced, and even where the 500 or more than 500 employees are there or the workers are there, and if any factory is engaging the hazardous processes or the chemical processes, then engagement of safety officer is made mandatory. And finally, ultimately, the documentation part is the annual return. Filing of the annual return in Form 27 is again mandatory. So you'll find that in most of the labor law, among these labor laws, the Factory Act carries maximum compliances, and one HR manager needs to ensure that this compliance is timely done. It is not only for the ISO, but otherwise also this is mandatory. And any non-compliance, because these factory inspectors, which are known as a dish, that is a Director of Industrial Safety and Health or Deputy Director Industrial and Safety. Earlier, they were known as a factory inspector. Now their designation has been renamed as a Director of Industrial Safety and Health or the Director of Industrial Safety and Health. And these factory inspector or the dish inspectors are basically engineer. Either they are mechanical engineer, civil engineer, or electrical engineer. They are not the ordinary persons, and therefore they strictly check these compliances. And any non-compliance, you know that in the state of Maharashtra, the fine is 10 lakh rupees, and including the prosecution. Prosecution means your employer can be put behind bars. So as far as HR manager, those who are representing these factories, they must ensure that the compliance is done very meticulously and cautiously as far as factory is concerned. SHW, which is sexual harassment of a woman at workplace. Very few complaints are there. Constitution of the IC. Now I think our time, we are running short of time. Within next 5 minutes, I'll complete my slides. Constitution of the internal committee with minimum 4 members is mandatory. Filing of annual report under SHWW Act, Sexual Harassment Act. It is not an annual return, it is an annual report. And conducting awareness program. So these are the 3 primary compliances which need to be done. I'll very quickly.
Sir, just want to confirm the time is not a concern. You can whatever time you want to take.
Thank you. I'll take another 5-10 minutes, not more.
No worries.
Yeah. How the corpus of these ESF funds are created? I'll tell you the employee contribution, it's 0.75%, employee contribution is 3.25%. So total corpus per month is from 4%. So by taking 0.75% of the gross salary of the employee, that is the employee contribution, it is given to the ESF fund, and the employer also. I'm sorry, here I have mentioned 3.425 as the employee contribution. The 3.25 is in fact employer contribution. So total it contributes 4%. Now let's see how the EPF, that is the Provident Fund, and the pension contribution or the corpus is formed. So how basically you will need to understand how this segregation of the employer and employee segregation take place. Employee, you see employee contribution 12%, that entire 12% goes to Provident Fund, right? Employees entire 12% goes to Provident Fund. Employer contribution 12% is divided in 2 parts. Part 1 is a pension fund, that is out of this 12% of employer contribution, 8.33% goes to pension scheme subject to maximum of 1250 per month, and remaining 3.667% goes to Provident Fund. So in all, if you see the PF contribution, earlier it was more, now it has become, after this introduction of the pension scheme in 1995, 16 November 1995, the pension contribution has increased and the PF contribution has gone down, which has come to 15.667%. It will go. So I think so this you must have understood. The employer contribution gets segregated in 2 parts, pension and Provident Fund, and pension is subject to 8.33%, subject to maximum 1250, and remaining goes to the Provident Fund. So this is how the contribution, while employee contribution, entire contribution goes to Provident Fund scheme. What is the upper salary limit for applicability of the Act? ESI becomes applicable once any employee has got 21,000 salary per month, that is a gross salary. Any employee or the worker whose gross salary is up to and inclusive of rupees 21,000 per month, he becomes applicable, he becomes covered under ESI. However, for this 21,000 salary, you cannot take overtime because overtime is a variable amount. On overtime, you need to deduct ESI contribution. However, overtime amount is not to be taken into consideration for computing this eligibility criteria of 21,000. This you must remember, because there are many companies or the HR manager or the payroll department create the confusion in their mind, which ultimately leads to non-compliance, and you have to pay heavy penalty and damages on that for non-compliance or non-payment of contribution. Because including overtime, many companies, they exclude their workers from the purview of ESIC. Please, I'll repeat myself, for 21,000 or for deciding 21,000, overtime wages are not to be taken into consideration. Why? Because it is variable. However, on overtime, ESI will be applicable. You have to deduct ESI on overtime wages, but overtime is not to be taken into consideration for eligibility purpose or applicability purpose. PF becomes applicable once if any employee salary is 15,000. Now here, what is salary under PF? That after Surya Roshni judgment of February 2019, you must be knowing that the Supreme Court has given the clear directions that what constitutes wages under Provident Fund. It is gross minus HRA subject to maximum of 15,000 should be PF salary. For the purpose of bonus, again, basic and DA, if it is up to 21,000, employee will be covered under Bonus Act. Gratuity, for gratuity applicability, earlier it was a ceiling of 3,500 rupees per month, and employees whose basic was above 3,500, they were not eligible for gratuity. However, around 10 years before, the government has come out with the amendment under Payment of Gratuity Act 1972, where the salary limit is removed. Now everybody, even though he is a vice president of the company, will be covered under gratuity. However, maximum gratuity payable as per law is rupees 20 lakh. So by way of calculation, by way of service, if any employee's gratuity goes 25 lakh rupees, his employer is mandatorily pay the gratuity to up to 20 lakh rupees only, and not 25 lakh. However, voluntarily employer can give on more amount also, but that excess amount or whatever is paid in addition to the legal provision or what is provided in the law will be taxed in the hands of assessee. Payment of Wages Act, now applicability, employee whose gross salary is up to 24,000, he will be covered under Payment of Wages Act. Rest will not be covered under Payment of Wages Act. Bonus we have already discussed about this 21,000. Now friends, we saw all about the applicability of the act to the establishment. We also saw about the eligibility criteria for getting covered under ESI, PA, bonus, gratuity for the employees. Now let us understand what are the non-compliances and the impact and effect of non-compliances. Friends, non-compliance is very dreaded. This is like a cancer, and once employee for any minor or the smallest default, it will be treated as a non-compliance, which will ultimately result wherever the contributory schemes are there, like ESI, Provident Fund, which are the contributory scheme, non-payment of contribution is treated as a non-compliance, which will attract damages almost up to 25%, and the penal interest, which is simple 12% simple interest for non-compliance under ESI PF Act. So also there is always hanging sword on the heads of your employer or the director or the partner, proprietor of the company, that they can be put behind bar by way of prosecuting them. So also CIBIL rating at bank reduces, CIBIL rating of the banks, because whenever your company goes for credit facility or the bank or the loan for its business purpose, the CIBIL rating is decided, and if you are defaulted on the statutory provision or the social legislation, and if any non-compliance is committed, your CIBIL rating will go down, which will ultimately impact these non-compliances. Friends, so these are the main three areas which we saw about applicability of the act when this becomes applicable to the establishment or the factory. We also saw, as I told you, that applicability of the act to the employees when it becomes, which is mainly related to your salary slabs, and the effect of these non-compliances, because you know that you have to take this compliance part very seriously. As a HR manager, you represent your company as far as the payroll is concerned, and these most of the compliances are either establishment related, factory related, and mainly payroll related wherever the contributory schemes are there. Friends, with this I concluded this presentation on the subject matter. The subject was very restricted, that is the applicability of the labor laws to the industry and various compliances as a part of their businesses. I'll open this session for question and answer. If you have got any questions, or if you have already submitted your questions in the chat box, I'll request my friend Ritesh to Rishabh to spell out those questions, so that I'll try to answer these questions from my side. Thank you. You have to unmute. You have to unmute.
I'm sorry.
Yeah.
I'm sorry.
No.
First of all, thank you so much from entire community member. It was a wonderfully made PPT, a presentation, and there are so many interesting points. For example, आपने बताया कि this is the fattest act we tell because उसमें 101 act है. So this is wonderful. Every single PPT, every single slide, every single point is very well explained. So I'll take up few questions from audience. In the chat, some I have written as I can show on screen, others I'll read directly. So this question, he's saying that, is bonus mandatory for contract labor? If yes, and not paid by contractor, is principal employer responsible for the same?
Well, this is very beautiful question. I don't know. You please mention. Can you mention the name of the person who has asked this question?
The question is asked by yes, it is BK Balodia.
Yeah,
Please
Mr.
keep
Bika
alluding.
Balodia, this is a very beautiful and practical question you asked me. If you would asked me this question after codification, my answer would have been different. Now you are asking me, so it is my duty to answer your question based on the present labor laws. As per present labor laws, the gratuity under Gratuity and Bonus Act, the indirect employees are not included. So the Bonus Act and Gratuity Act, the gratuity is not applicable to the contractual employee. It is not the responsibility of principal employer to pay the gratuity and bonus. However, as a good governance practice, all employer, principal employer must ensure that when they are giving bonus and gratuity to its own employee, they must ensure that the contractor also gives gratuity and bonus to its employees. And for that, you should ask them, as principal employer should ask them to inbuild that cost in the monthly invoice which the contractor raises to its employee. But as per present law, the gratuity under Gratuity Act and Bonus Act, indirect employees or the contract employees not included. However, in the codification, this has been well taken care of, and the codification of the Labor Law, Social Security Code, now indirect employees or contract employees will also be covered under this Gratuity and Bonus Act. So I'm telling you this, after codification, my answer will be different. This what answer I am giving you presently today, that based on the present laws. However, there is recent, I'll add one more point, that as far as gratuity is concerned, very recently, there is a judgment of Madras High Court which has stated that the Gratuity Act will be payable. This is a judicial interpretation basically. It is not challenged in the higher court, in the Supreme Court. But as per the Madras High Court judgment, the case law says that even the indirect employees or the contract laborers are also covered in the Gratuity Act. But with all due respect to the honorable, this judgment of the honorable Madras High Court, I differ on this particular point. I don't know how it was presented.
Okay, sir. Thank you so much. Next question it is on trust. As you mentioned that most of these are exempt from the trust, so they are asking to confirm it again. A trust is exempted from all these list of labor laws, or are there any specific laws which they are exempted?
I'll focus on this again. Good question asked by the questioner. Well, I will focus my discussion on this on three aspects. One is the payment of bonus, then payment, this Provident Fund Act, and the ESI Act. As far as trusts are concerned, basically these trusts are either registered under Societies Registration Act or Public Trust Act or the Cooperative Societies Act. Now these trusts, from 2015, the PF Act has been made applicable to all trusts, whether they earn profit or no. Earlier, the exemption was granted to all NGOs prior to 2015 till 31st March 2015. From 1st April 2015, all trusts have been covered under the provisions of Provident Fund. As far as bonus is concerned, if any trust is incurring any profit or doing commercial activity, because as you know that there are a large number of trusts are there who works in the village area, remote area, and they give some employment to the localites over there and ask them to do some cottage industry work and sell in the market, and some revenue is generated out of that. If any trust is engaged in such type of activity, the bonus will be applicable to it. As far as applicability of ESI is concerned, at certain places it is under dispute, because you know that Ramakrishna temple, Hare Rama Hare Krishna temple, that judgment is still pending before the Supreme Court. The ESI applicability of the ESI Act, they have challenged it, but ESI per se, they make ESI Act applicable even to the trust also, wherever the commercial activity is carried out.
Okay, sir. Thank you so much. Next question is a basic one. They are asking what is the difference between floor wage and minimum wage?
Yeah, well, floor wage is an incomplete word. You should call it as a national floor wage. And this national floor wage this particular word has not come in existence so far, because it is a part of codification in the Code on Wages 2019. This particular word is defined national floor wage, for which very recently government has appointed a committee to advise government on what should be the national floor wage. As far as minimum wage is concerned, it is decided by the respective state government, which is defined. Minimum wage is defined, which is presently in existence, which is defined under this Minimum Wages Act itself, which comprises of basic and dearness allowance, and it is decided by the state government. Now, what is the correlation? Rather than asking the question, what is the difference between national floor wage and minimum wage, I'll tell you what is the correlation between this NFW, that is a national floor wage, and minimum wage. See, in codification, in Code on Wages 2019, the central government has clearly stated that the central government will fix amount of national floor wage, and no state government will be able to pronounce or announce or declare minimum wages for its states which will be below national floor wage. So, for example, I'm giving you citing one example. If the government tomorrow says they appointed a committee now to advise government what should be the national floor wage, and that committee says, and if the proposal of the committee or recommendations of the committee are accepted by central government, and if the central government declares that national floor wage across India is, let's say, 14,000 rupees per month, in that case, no state government will be able to declare, notify their minimum wages, that is basic and dearness allowance, which will be less than 14,000 rupees. So that is a correlation between them. But so far it has not been notified national floor wage because the codes are not notified. Codes are just enacted, not yet notified.
Okay, sir. Thank you. Next question is very interesting question. Are security guards can be said workmen? Can security guards be deployed for 12 hours in a day? So this is, I guess, this is a common situation across industries.
Yeah, I understand that. But is the questioner from Maharashtra? Because in Maharashtra, different position is there. Maharashtra.
Okay, you can explain from both angles, Maharashtra and national, I believe.
Yeah. Because Maharashtra, for governing the working condition of the security guards, we have a Maharashtra Private Security Guards Regulation of Employment and Conditions of Service Act 1981. That particular act, and this act is applicable only in the state of Maharashtra, not other places. So I'll tell you the first position in other states, and then I'll come to Maharashtra. But if you are not from Maharashtra, don't get confused about, because I'll tell you. As far as security guards are concerned, they are very well workmen. Basically, they are very well workmen. Their names, their number of our security guards are to be included. This I'm telling you, other than Maharashtra, are to be included in the contract labor registration certificate license. All these labor laws are applicable to the security guard also. They can raise the industrial dispute also under ID Act. Industrial employment standing order acts are also applicable to the security guards. And as far as deployment of the 12 hours duty is concerned, any employer can ask security guards to work for 12 hours, right? Just like the drivers, they can be asked to work for the 12 hours. But please remember, any work done in excess of 8 hours should be treated as extra duty hours, and overtime at double the ordinary rate of wages must be paid to these guards. In Maharashtra, since there is a regulatory, different act is there available, Maharashtra Private Security Guards Regulation of Employment and Conditions of Service Act 1981, it says that you can very well engage the employees for security guards for 12 hours, subject to this condition of payment of overtime. And there in Maharashtra, we cannot include security guards in the contract labor registration certificate and license. The government doesn't give license to the security guards in the state of Maharashtra. I don't know about the other state, what is done in the Rajasthan, I don't know. That I think you will be able to answer.
Oh, okay, sir. Thank you. Next question is again a basic one. He's asking that if an employee is covered under ESIC, she will not get the benefit of maternity benefit. He has also asked a further similar question. So confusion about if ESI is applicable, maternity benefit milega ya nahi.
Yeah, it is not only for the maternity. For any incidents, you cannot claim the benefit from two different sources. I'll tell you, if you are taking a benefit in case of accident, if you are taking a benefit from under Motor Vehicle Acts, you cannot take the benefit under Employees Compensation Act. The court has already given. Same way, if you are taking a benefit, first of all, employees who are covered under ESI Act are not covered under Maternity Benefit Act, even though the benefits are same. But there are certain employers are there, because you know that under ESI Act, the maternity benefit is given based on the wage structure prior to 9 months. While under Maternity Benefit Act, the maternity leave compensation is given based on the current salary. So many employees, they prefer to take this maternity benefit from the employer. However, it is not mandatory. Employer not to pay it, right? And if any employee takes the maternity benefit under ESI Act, if she is covered under ESI Act, she has to take from ESI. And if she takes, she cannot claim from the maternity employer, and employer need not to pay any benefit.
Okay, sir, that's very clear now.
Incidents, you can take the benefit from two different sources.
Okay. Next question is, how much amount the employer has to give if the employee dies without 1 year completion of service and without filing the nomination?
This is under which act question? Gratuity Act?
I believe, yes, gratuity. And he has asked a further question. If an employee dies due to COVID before 5 years, will he be eligible for gratuity?
See, COVID is a cause of death, basically. A might dies because of any reason, not necessarily COVID. COVID is not something special. He can die. It is considered as finally the natural death, basically, not accidental death. So in such cases, now please understand that if your question is pertaining to the first part of your question is pertaining to the gratuity, then in that case, if any employee, I'm giving the legal position. If any employee has worked for less than 1 year of the continuous service, then gratuity is not payable to him, even though it is a death case. Because under Gratuity Act, for payment of gratuity, minimum 1 year of continuous service under gratuity he should work. Now here, year means what? Year does not comprise of 365 days. As you know that if the 6 days week, it is 240 days. So within 8 months, employee can complete one continuous year, and if he has worked for 8 months, he is eligible and dies, he is eligible for gratuity. But after 5 months, 6 months, 7 months, if he dies, the gratuity is not payable. However, amount is very minor, 15 days salary per year. So most of the employer, they pay as a gratuity or ex gratia to such person.
Okay, sir. Okay. Now a question I believe is a very difficult question. So if a gratuity, what is the minimum criteria? Is it 4 year, 10 months? Some people say it is 4 years, 6 months. Some years say.
I'll tell
So
you.
what
No,
is
no,
the exact number, sir?
yes, I'll take this question. It is very, this question is to my heart, basically, because I have fought many cases in the court, in the tribunal, and with the competent authority as far as this continuation of the service is concerned and year is concerned. See, under Gratuity Act, I just now had mentioned that year comprises of 240 days and not 365 days. If it is a 365 days, then you have to see that 4 years and 12 months employee should work. But as wherever the 6 days week is there, the employee can complete 1 year or 8 months within 240 days. And wherever 5 days week is there, he can complete within 190 days. So in case of the company where 5 days week is there, it is considered, and this 190 days one can complete within 6 months time. So in case of the company where or the employment where it's a 5 days week. In that case, once the employee completes 4 years and 6 months, he is eligible for gratuity of 5 years. And in where the 6 days week is there, in such cases, employee is eligible for gratuity once he completes 4 years and 8 months.
Okay.
I won many cases on this, and the department has also accepted this stand. So it is not 10 months or 11 months, and there are large number of cases of the even Honorable High Court has also delivered the similar type of judgments.
Okay, so the final stand is अगर 5 days a week है तो 4 years 6 months, and if 6 days a week then 4 years 8 months. उसके ऊपर eligibility हो जाएगी. And what about continuity, sir? If it is below 240 days in a say 8th year, what will happen for that particular year?
See, now whatever period is there, it should be continuous service. Now for the purpose, now what is the non-continuous service? Non-continuous service is the service which is interrupted because of the illegal and unauthorized absenteeism. But if it is interrupted because of the maternity leave, if it is interrupted because of the sick leave, such leave is to be taken into consideration for continuity of the services. Only unauthorized and illegal leaves are not taken into consideration. Then that will be considered as a break-in service.
Okay. So if the service is total 10 years, and in 8th year he has taken some leave, not unauthorized, but taken leave and only came for say 150 days, then will we pay for 10 years or minus 1 year?
No, it is the year in which he has worked for less than, if the continuous service of 240 is not completed, that year will not be considered for the payment of gratuity.
Perfect, sir. One again very simple question. It is about ESIC. So why ESIC in Maharashtra was 20, applicability on 20, when across the India it was 10 earlier? And do state government has power to increase this limit?
No, see, ESI, as I told you that October 20 onwards, even for the establishment also, as I told you that ESI applicability differentiate between two parts. One is a factory, another is the establishment. Now, establishment, in the act itself, it is stated that the ESI will be made applicable to the establishments. I'm not talking about factory. To the establishment, it will be made applicable by virtue of state government notification under section 1.5, while factories are covered under section 212. Which is issued by the central government. So under section 1.5, the state government has to come out with the notification. Now in October 2020, they have made the applicable. Earlier it was with 20 and above 20 employees. Now it has been made applicable with 10 and more than 10 employees, even for establishment also.
Okay, sir. Last couple of questions I'm taking. This question is related to PF. Is an employee who has withdrawn the PF amount and now he has started working as director or maybe anywhere else, whose salary is more than 15K. In such cases, whether director or that particular employee can be exempted from PF.
Yeah, it's a good question you asked me basically. See, please understand, PM doesn't recognize whether he's a director or he's a manager, vice president, because the membership is not based on the designation. Membership is based on the membership itself. The membership criteria is there based on the salary. Now, even though any employee's salary is more than 15,000 rupees, moment he becomes member, he continues to become a member. Unless until he wants to migrate out of India or for the marriage purpose, if any lady wants to leave the company, then that time she or he ceased to become a employee. Now, in this case, earlier he was a member of Provident Fund and now he has become the director of the any particular company, but he continues to be a member, and provided if he is drawing a salary, if he is taking remuneration from that company where he is working as a director, in such cases, he will continue to be a member up to 15,000 rupees salary. Even though he is drawing per month 1 lakh rupees salary, up to 15,000, he should be covered. So minimum 1,800 rupees must be contributed.
Okay. Sir, this is the last question from the audience. Is constitution of compliance under minimum act, does the act state when any case the minimum wage notification are not published, the older minimum wage shall continue? ऐसा कहीं mentioned है क्या?
Yeah, see, Act never speaks about the negative language. It will not say that this is not applicable to you. It will always say that under so and so circumstances, with the proviso with the proviso and the recommended clauses, it will say it is applicable. The Act never use the negative language. That is basically the structure or the standard of writing the. That is how the laws are written basically. So please understand, if any state government or appropriate government, I'll use the appropriate government because there are certain industry for whom appropriate government is the central government, and the central government has to declare the minimum wages. And for where the appropriate government is the state government, then state government has to declare the minimum wages. So for whatever reason, if the state government delays the declaration or pronouncement or announcement of the minimum wages or the dearness allowance, the special allowance, till that time the old rates will continue. You don't have to assume that 10% will increase, I'll take additional 10%. Till that time, the old rate will continue. However, whenever the state government declares the minimum wages, they always declare it from the retrospective date, back date. So so whenever these rates are declared, so you have a ready-made figure in your hand, you have to work out the arrears amount and pay it to the employees of your company.
Okay, sir. I missed one question. If you permit, I'll take this last question.
No problem.
So he's asking about education sector Maharashtra minimum wages. I'm just generalizing this question. What are the minimum wages which are applicable on school education sector in general, because they are not mentioned in minimum wage notification?
Yes, very good question actually you asked. Well, as far as education sector is concerned, it is divided in two parts. One is the aided, another is the non-aided. Non-aided, but as far as aided are concerned, the wages rates are fixed by the state government or central government, or whatever 10th pay commission is applicable, same rate they will have to give. But for private sector, where the unaided are there, or the education sector where the private education sector are there, presently, again I am telling you, I'll divide this my answer in two parts. After codification, education sector will fall under this category of minimum wages as on today. Today we are in pre-codification area because the codification is not yet notified. As on today, education sector is non-scheduled industry or non-scheduled employment under Minimum Wages Act.
Okay. I guess that concludes everything, and all the questions as well answered very well. So thank you so much for giving your valuable time. We appreciate it very much, and bottom of heart पूरी community की तरफ से बहुत शुक्रिया सर आपको हमारे साथ जुड़ने के लिए.
Thank you very much. Just 1 minute, a few words from me also. Yeah, thanks for giving me this opportunity to address all LLA faculties. Basically, you are doing a wonderful job by sitting in Rajasthan. Basically, Rajasthan is historical place, famous for so many things. But I think so this is a new chapter, especially the 24 webinar you are conducting, and I hope that very soon you will be concluding your silver jubilee. And I request you to call me for this silver jubilee function of your webinar. Basically, thank you very much once again, and I hope I adequately address the topic given to me. I have done a justice to the topic given to me and address all the queries of your members' participation. Thank you very much, and good night, everybody.
Thank you so much, sir. Thank you. दोस्तों, उम्मीद करता हूं आपको आज का वेबिनार पसंद आया होगा। बहुत ही इंटरेस्टिंग वेबिनार, मतलब मुझे पर्सनली एक एक मिनट इतना ज्यादा वैल्यूएबल लगा इस वेबिनार का, गजब। आपसे मिलूंगा 2 दिन बाद एक और वेबिनार में, जब हम सीखेंगे किस तरह से आप ग्रेट प्रेजेंटेशंस बना सकते हैं। संडे को आपसे फिर मिलेंगे। आज के वेबिनार में जुड़ने के लिए आपका बहुत बहुत शुक्रिया।